Right, okay, welcome back to the show. And as we say, very, very busy show this morning. We haven't had time to get around to all the messages we've got in relation to Stephen Donnelly's interview, and we'll hold them off till Monday. But, of course, we go to the polls 2 weeks from today. On Friday, the 8th of March, was International Women's Day, to vote in two referendums, referendums on family and on care. The family referendum will be a vote on a proposed amendment to Article 41.1 of our Constitution that will broaden the protection offered to the family to include families other than those based on marriage, so-called durable relationships. And the care referendum concerns a vote on a proposal to replace Article 41.2, which includes a reference to women in the home, and to insert a new Article 42B to provide recognition for care within families. Now, over the next hour or so, we hope to make you more aware of the issues involved and to give you more clarity to help you make up your minds on which way you will vote. And to help us to do that, we're joined in studio this morning by four guests, two advocating a yes vote and two a no vote. Now, our panel this morning, on the yes side, Claire Duffy, who is Policy and Public Affairs Manager with Family Carers Ireland, Midlands Northwest Fine Gael MEP Maria Walsh, and on the no side, Independent Senator Ronan Mullen, and Sandra Adams of the Countess Group, which was formed to promote the rights and interests of women and children in Ireland. And we thought, well, first of all, I want to say good morning to you all and thank you for joining us, because I know you all four of you travel long distances to be with us here today, so we do appreciate your attendance on such a miserable, wet morning. If you do want to contribute to the debate, or indeed, probably more relevant, if you want to ask a question or need clarification, phone us now or text. Phone us now, 071 911 8104 is our number, or you can text on 083 3500 530, or indeed email your comments to comments@oceanfm.ie. So before we delve into the debate itself and some of the finer issues, I just was hoping we could get a brief 1 minute or less outline of why you're voting the way you are. And we start with the yes side, and maybe Claire, we'll start with you, Claire Duffy of Family Carers. Good morning.
Okay, and I'm delighted to be here this morning. And Niall, as you said, I'm Claire Duffy, and I work for a national charity called Family Carers Ireland. And we've been in existence for 37 years, and we exist really for the sole purpose of trying to improve the lives of family carers. So we are campaigning, as you say, for a yes vote in the upcoming referendums. I guess there's three main reasons why we're voting or campaigning for a yes vote. One is just for the absolute recognition that the enshrinement of care in the Constitution would give. I can't overstate how frustrated and angry and undervalued carers feel, and having care enshrined in the Constitution really is a milestone moment for carers in recognising and valuing the immense contribution that they make. Secondly, and really importantly, 39% of carers enumerated in the census in 2022 and actually in 2016 as well are men, and our Constitution is entirely silent on those, in specifically Article 41.2, and that's not right, and it has to change. And then finally, we believe that by inserting Article 42B into the Constitution, it gives us a platform on which to achieve real, tangible supports for family carers. And I'm thinking about things like the abolition of the means test, giving carers a right to respite, a right to support. So all of those things won't happen, of course, on the 9th of March if it is passed, but it is things that we believe can be achieved over time. So look, just to say, we know the wording is not perfect, but we do believe it offers us an opportunity to improve things for carers. Okay,
Maria Walsh, MEP.
Yeah, I'm voting a double yes, as is many in the Fine Gael party, and hopefully many listening based off this conversation will have more information coming from both sides, which is fair and democratic. But from my side, Claire touched on the point on carers. For me, let me just focus on family. Right now, the Constitution that was designed and developed in 1937, in my eyes, doesn't reflect the modern country we live in now, very much based on marriage between man and woman. We know in the most recent years, between marriage equality and between many other referendums where we've made amendments to our Constitution, that the broadening of definition of family is much needed. Hence the reason for me it's an important yes. We have very different types of family units. You have single parents, proportionally women. You also have guardians or grandparents as a family unit with their grandchildren, and you also have folks like myself who are LGBTI and perhaps are in a long, durable relationship and have children. And right now, there is well over 40% of children born in Ireland now born outside of marriage or civil partnerships. And in my eyes, our constitution needs to be updated and modernised to reflect the country we're living in. So that's from the family side, and Claire obviously covered the care side.
Okay, Sandra Adams of the Countess, so you're voting no.
Yes, the Countess is an advocacy group for the rights of women and children and to ensure adequate safeguarding. We're advocating for a no on both proposed amendments. On the so-called carers proposal, the language in it is unenforceable, and it will ensure that the government can sidestep its obligations to disabled people and indeed to carers. It neglects even to mention people with disabilities. With regard to the removal of the words mother and woman, we would be extremely concerned at any attempt to remove sex-based language from policy and law, because we believe it's necessary to acknowledge the differences between men and women. And it's worrying to us because it's not the first time the government has attempted to excise the language that women rely on to describe themselves. Last year, they tried to remove the word woman from maternity legislation, as implausible as that sounds. And they also attempted to remove the word woman from cervical check screening programme literature in 2021. So for those reasons, we're advocating a no on the carers proposal. With regard to family, our founder, Leisha de Bruin, is a practicing barrister, and she has, with many others, identified that the lack of definition on durable relationship will result in chaos because it will affect inheritance, pensions, social welfare and taxation. And it's not appropriate for the Minister, Roderick O'Gorman, to state that it will be up to the courts to decide what a durable relationship is. We elect TDs to make those decisions for us. With respect to judges, we did not elect them to make those decisions or policy.
Okay, we'll come back to that issue very, very shortly. And Ronan Mullen is here, Independent Senator Ronan Mullen, again advocating a no vote. Why so, Ronan?
Well, essentially, Niall, and thank you for bringing us all together to debate this issue this morning, because it will do much more harm than the good that it claims it seeks to achieve, in a nutshell. First of all, this is a remarkably strange process that has gone on. A coterie of people around the minister have cooked up two controversial wordings, and at every point they seem to have wanted to close down debate. They refuse to publish the minutes of the interaction, 64 pages of interdepartmental minutes about the implications of the wordings of these referendum. They got rid of the pre-legislative scrutiny. Remember, the Constitution is the pillar, is the bedrock on which our laws stand. And before a question or questions are put to the people, it's vital that there would be proper testing. That didn't happen in the Oireachtas. They rushed the debates through. It seems that there was a deliberate policy to minimise scrutiny of what these words mean. So we're left with a pig in a poke referendum. People have talked a lot about the massive legal uncertainty caused by this phrase, durable relationships. Nobody knows whether it means threesomes, whether it means includes relations on the side, how long those relations have to last you. And we're told go to the courts. The chaos for tax, inheritance, pensions. We'll get back to all of this. But you see, the government could have given us a wording, and in fact we had an amendment down, that would have respected families that weren't just the ones based on marriage. Everybody's in favour of inclusivity, and we're able to pass laws as things stand. As we saw in the O'Mara case as well, the courts are able to make good rulings that guarantee the rights of people outside of the marriage-based family. The referendum could have offered substantial, real good stuff for carers. They haven't. Nothing like the language on the state shall provide for free primary education. Just a vague, watery aspiration, while at the same time dumping on the role of parents in the home, getting rid of the only reference to mother in the Constitution, missing the opportunity.
All right, well, we'll come back to some of those points you make in more detail. Well, let's go to the durable relationship wording, which Sandra first mentioned. Claire, in your eyes, what is a durable relationship, and how is it different, or how should it be different from a family only founded on marriage? Is there a confusion? And again, you mentioned some of the wording might have been better organised or better structured, but are you happy with the fact that durable relationships remains in the wording in the amendment?
I will start by clarifying that we are looking at this very much from the lens of the family carer, and our focus is on 42B. But durable relationship, as I understand it, is a recognised term across Europe, and it is up to the Oireachtas to define the parameters of that. And then if people, obviously, and I think as Ronan said, if people fall outside of that, it will inevitably go to the courts. But, I mean, I had the luxury of sitting in Leinster House for 5 hours while durable relationships was being debated, and thruples and polyamorous relationships and all of that. So it is one of those terms that has caused confusion, and I'm not going to try and defend something myself that I have struggled to get my head around.
Yeah, as a lot of people are. But the situations you mentioned, are they red herrings in the debate as far as you're concerned from what you have heard so far?
When you say situations, Niall,
triples and polyamorous relationships, etc., because that's what a lot of people
I do think they are a distraction. I certainly do think they are a distraction. I think at the end of the day, and as Maria had said, 40% of children today in Ireland are being born outside families which are defined in the Constitution. About 1 million people in Ireland are living in families that are not recognised in the Constitution, and that just can't happen. We need a Constitution that is modern, progressive, and reflects the society that we live in, and it simply doesn't do that.
Yeah, that is the case, Sandra. I mean, the current Article 41.1, do you think it doesn't reflect our country, our modern country's values, which is very basic, is it not? And at the heart of the entire debate, or should be.
Well, I think it's important that we recognise that, illegitimacy was abolished years ago. Children are considered equal under our Constitution, irrespective of the marital status of their families. And this amendment doubles down on the presumption that families involve more than one adult. Single parents are not in a relationship with anyone else because they're single parents. They're not covered by durable relationships, because to be in a relationship, there has to be another person. I think it's something's going on here. We're declining. The state is. Some people seem to decline to want the state to recognise their relationship, while simultaneously complaining that the state is not recognising their relationship. We had civil partnership before the equality, marriage equality. We could introduce legislation that would recognise civil partnerships. We have cohabitation laws that could be expanded. I think there's a lot more to it that we could do through legislation. We don't have to change the Constitution in order to do that.
Yeah, okay. Maria, I mean, I think it was either Claire or Sandra mentioned the fact that this could end up... and nobody has been able to answer the question, I think, that I can see. What is a durable relationship? What constitutes a durable relationship? That ultimately it may be the courts, the judges who will decide. There is
an answer. It could be anything at all.
Yeah.
No, that's not correct. I mean,
it is correct.
Is it reverse democracy then, Maria?
No,
because
as Claire pointed out, it's a European legal term. It has been debated and discussed, and collectively the term durable was put forward, and I think we've heard from I know we've heard from several leaders within the government, my own party leader in Taoiseach Leo Varadkar, that we are not seeking to bring novel concepts that have never been recognised in Irish law, such as polyamorous marriages. That has not been the case, and our courts are very clear on that, and the past remains. Ultimately, at this point, if anybody took out their laptop or phone or desktop, whatever their searching device is, and you typed durable relationship, you would find a definition that is 2 years plus. Your legal documentation might be a mortgage, might be even down to a utility bill, might be down to banking statements, various things. And actually, in many cases, and I heard Senator Mary Seary Carney point this out over the last weeks around this term when other people were in debates against it. We have a judicial system, and thankfully, unlike many countries, we have a very free legal judicial system.
Yeah.
It is down to them. If someone wishes to take this to court, that is what they're there for. Politicians shouldn't be involved in that, nor organisations. It's down to the judicial system. But many, if many, will never go to it because what I really feel is this change ensures that, as Claire and I have both stressed on many times, that the over 40% of children are not currently represented by and protected by our Constitution. Many families and family units are not protected by our Constitution, and we need to modernise and ensure that we are delivering change as we have done in the many other referendums that we have. 38 referendums have come before the people since its inception in 1937. 32 of them have made changes and have made changes for the better, like us entering into the European Union, like the concept of divorce, like marriage equality, like repeal the eighth. So this is one additional step.
Okay, all right. Rhoda Mullen, you have said already in the round that you felt the debate and the introduction of the referendums was rushed and there was no pre-legislative scrutiny.
I think that was deliberate.
Deliberate on the government's behalf? Why so? I think you've an issue with the fact that the votes are on International Women's Day as well.
I have an issue with the fact that they rushed. Delighted if they could have been on International Women's Day if they'd started in time, but rushing and trying to prevent proper scrutiny. I mean, just to give an example, Maria just said there, it's a European legal term, don't worry. But you can't define...
No,
but you can't define
that's not what I said.
if it is a European legal term, how come the government can't tell us what that legal term means? She says the Constitution doesn't protect families outside marriage. That's not true. There isn't a single benefit that children or indeed people outside the marriage relationship need that we need to make to change the Constitution in order to deliver. We have that flexibility in the Constitution, which is great.
Well, let me just stress in there, with greatest respect, Senator, your narrative on this being pushed through in the government is not correct either. I mean, a decade ago, the Constitution Convention had put forward this at a survey of 100 people who were brought together to make this happen.
This wording was cooked up recently, Maria. This wording was cooked up recently, and we were given minimum.
The concept of family being reviewed, the concept of 42B being reviewed.
It's the words that matter. It's the words that matter.
Well, your words matter. So this is really true.
If you put in vague words and you kick it into the air and say, "Don't worry, the courts will sort it out." Think of all the people who can't afford to go to court in order to secure their rights. Think of the people who might discover...
Think of the people who are not protected currently under our Constitution.
No, Maria, they are protected. Think of the people...
Over 1 million people are not currently protected in our Constitution.
You cannot point to a single disadvantage that we need to change the Constitution.
I can tell you this. I know several
hand,
LGBTI couples who have children.
Just finish one. I want to move on to other points.
Just
right.
finish the question.
Okay, finish the point, yeah.
There isn't a single benefit that is needed that we need to change the Constitution in order to deliver. On the other hand, you could be a person, there was a legal friend that said it to me recently, from now on, maybe where there's a will, you'll be sure to find a durable relationship. So somebody who's expecting to inherit from their husband or from their wife under a will and discovers and has to go to court and be dragged through the courts because suddenly at a vulnerable stage in their lives, they discovered that there was another relationship all along with or without children.
So it has implications for succession law.
Claiming equal family rights, which is what Roderick O'Gorman is giving them. Okay.
Anybody else want to come in on that point before we move on to other
just
points?
to say that I think the whole thing of
Sandra,
thruples and so on, it is a little bit of a distraction, but it's adjacent to the problem because we don't recognise polygamy in this country. It's not legal, okay? So we can leave that to one side. But the courts won't be asked to adjudicate on whether or not a polygamous marriage is legal. They'll be asked to adjudicate on whether or not it is durable.
Yeah, exactly.
And that is the point. So if you have 3 people and one of them passes, the 2 who are remaining, do they both have rights to pension, to inheritance, to taxation relief? That's the problem. It is a distraction to a point, but it is adjacent to a very real issue, which is durable relationship is not defined.
Okay, I should have pointed out that we're dealing with the family amendment first in the first part of the debate, and then we'll take a short break and we'll come to the care amendment. Claire, I think it was you who said at the start, I think the vast majority in this country, is it the case, would agree that the definition of family should include unmarried couples and so forth. Nobody would disagree with that, would they? I don't think. What do you feel?
That's what I thought at the beginning of this process, Niall, to be honest. I find it hard to disagree with that. I find it hard to think that my daughter could be sitting in her classroom next to a child who is in a non-marriage family and one child is recognised in the Constitution and the other isn't.
But that's not true. All children are recognised in the Constitution. Article 40 confers equality on every citizen of this country. That is the article that John O'Mara relied upon to secure his pension after the death of his partner. They were not married, because the state recognised that we have an obligation to treat all children equally. That is not true to state that children are not treated equally.
Okay, just let Claire finish. Yeah. Right, okay.
Of course, they could have been, and we had an amendment down. There would have been no problem with extending the recognition to family based on marriage and family based on relationships other than marriage. There was a way to do this, but they've chosen a way that actually destabilises the protections that are there for vulnerable people. And that's what's really alarming about this. And that's why it's so harmful that they closed down the discussion and just rushed it through.
Okay.
I just make that point now, because the narrative about this being rushed is not factual. So I'll finish my point.
Why do you say that?
The Constitutional Convention over a decade ago, between 2012 and 2014, looked at 10 issues.
Which you feel is generally
ago.
representative, you would think?
Say that again?
It is generally representative of what people might want to change in the Constitution?
Correct. So 100 people came together. They were selected, hence the Constitutional Convention. Of the various 10 issues identified, reviewing family and actually more in particular the care referendum was fourth issue. If I have my rights, if I have that right, it was like 29% polled, and that's what they wanted to look at. From there, the government set up a task force to further investigate in 2014.
Nobody's discussing any of that.
No, but when you
just let Marie finish her point,
Ronan.
I'll come back to you.
Because there's a narrative which, for people listening, and this is who we're speaking to, people who are listening, trying to gather all the information and make the best decision for themselves and their own families and the wider community. There's this narrative that this was rushed. It wasn't. It has been actually not rushed enough in my eyes, in the sense that we should have had this question to the people a long time ago, but other referendums stepped in, like marriage equality and repeal the 8th. And I know our next piece will look at cares. I mean, that's a significant moment in time that has been asked for decades, Claire. Am I correct?
Yeah,
so the narrative about this being rushed is simply not true when you look at the fact that the Constitutional Convention, people had gathered, and the various steps the government had put through to make sure this is done right and done correctly.
Can I just respond to this? And I don't think Marie or the government intentionally, I hope doesn't intentionally mean to mislead people here. There's no dispute that the general issues have been in the air for the long time. But what matters is the words. Sorry, it is precisely what I'm saying, because what matters is the words that were cooked up recently by a small coterie of people. Let's just point to what the government has refused to do. First of all, when they had a consultation on the recommendations of the Citizens' Assembly, which they've departed from by a considerable degree, there was a public consultation. The Minister has refused so far to publish what the public had to say on that subject. Secondly, before Christmas, at a quiet committee meeting, it was decided not to have the normal pre-legislative scrutiny of the legislation, where there could have been an early scrutiny of this precise referendum wording proposal. Thirdly, they rushed through most of the stages in the Dáil considering this issue in one day, and they did the very same thing in the Seanad, and they guillotined the debate. Now, if that doesn't point to a government that wants to close down the debate and try and win it over a short-term referendum over a few weeks, what does?
Okay,
and I think what's going on here is that Roderick O'Gorman and others, and the final thing, they will not release the 64 pages of interdepartmental minutes where they actually went through what these proposals would.
Okay.
That shows a secretive approach to power that is far from democratic.
Just a couple of texts coming in so far. Our Supreme Court has already ruled that polygamous relationships are not legal because they breach the overriding principle of equality under Article 40 of our Constitution. That is why triples and the other red herring relationships thrown in here will not be deemed durable.
That's incorrect.
Two people living together are in relationships for years, are not entitled to anything, and that's something that needs to be clear. I'm a single parent. I'll be voting no, and I'm not changing my mind. The rights of women are actually protected under the Constitution. It brings in the concept of fake news to say or even suggest that a woman's place is in the home. How misleading is that, says Deirdre. I don't think it matters which way we vote. If we get it wrong, we can hold it again and again and again until we get it right, just like what happened before. That's maybe something
nobody is suggesting, Niall, nobody is suggesting that the courts are going to turn around and legalise bigamy. That's not the point here. The point here is, in the context of our evolving migration story, and Neil Richmond, by the way, admitted that this is connected with immigration law, that you could have a situation where somebody claims the rights for more than one spouse to which they were legally married in another jurisdiction and now want to be reunited with them in Ireland. It is hard to see, given that the Minister has said that there will be no differential treatment between families based on marriage or families based on durable relationships. The claim will be made in the court, and this is the chaos we're facing, that they now have rights. And the interesting thing is, the Minister has closed down the ability of the legislature, the Dáil and Shannon, to legislate this. It's straight to the courts.
All right, just Sandra, again, above and beyond the arguments we're having and the nitty-gritty of it, the fact is that in the Constitution as it stands, we're excluding thousands of families that are not considered families, and it's so important that they be included. Would you accept that at all?
I think,
in the round?
Yes, I would accept that families need to be included, but this is not the wording to do it. And I agree with Ronan. There were many amendments placed before the Seanad, and there was no opportunity to discuss them. I think the 60 senators were given 3 minutes each in a 3-hour debate. So there's something that is just inappropriate. We cannot conduct our country in that way. So there's legislation that can protect people and protect families, and we had better wording offered to protect families in the Constitution, but it wasn't even discussed.
Okay, and just on the wording, I'll just ask you again, Claire, you have a difficulty with some aspects of the wording, but that aside, you still feel a yes vote is the way to go on the family one.
Yeah, I mean, look, Family Carers Ireland have been criticised for supporting a yes vote, and I have to emphasise that we didn't decide on the 8th of March when the wording was published that we were going to go with this. There was a lot of thought and consideration put into this. We have been engaging in this process since 2018. We appeared in front of the Oireachtas Committee on Justice about Article 41.2. We have made written submissions. We contributed to the Citizens' Assembly's deliberations on Article 41.2. We appeared before Ivana Bakic's Committee on Gender Equality. We made written submissions. So when the wording was published on the 5th of December, it was discussed, it was considered by ourselves, and we decided to campaign for a yes vote for the reasons I set out at the very beginning. We actually do believe that while the wording isn't perfect, it's better than the status quo, and we can work with that to deliver real and tangible results for family carers over a number of years. And I mean, we would not be campaigning for a yes vote if we did not believe we could do that.
Right, I tell you, we'll take a very, very quick ad break, and we'll be discussing the issues arising from the Care Amendment with our 4 panellists next.
Tell us what's up. WhatsApp 083 3500 530.
Peacock Lane, Ballysadare, Sligo, the ultimate family dining experience. Join us for our early bird menu every Wednesday and Thursday from 5 p.m. and every Friday and Saturday until 6 p.m. Enjoy 2 courses for €20 or 3 courses for €25. Book now for communions, confirmations and Mother's Day at peacocklanebookings@gmail.com with live music, warm ambience and takeaway options available.
Go full Lidl with Board B approved Super Savers exclusively on Lidl Plus. Fry Irish turkey breast mince was $4.29, now $3.39. Dice up Irish mushrooms were $1.09, now 59 cents. And our Lidl Plus wine of the week, Chianti Reserva, was $10.99, now $8.79. Scan the Lidl Plus app and go full Lidl today. Get the facts for Drinkaware, visit drinkaware.ie.
Discover the magic of home with Castle David Furniture Sligo, your destination for exquisite furniture and unmatched style. Transform your living space with our curated collection of timeless pieces, meticulously crafted for comfort and elegance. From classic to contemporary, Castle David Furniture Sligo offers a diverse range to suit every taste and budget. Visit our showroom today in Sligo Retail Park or explore our latest designs at castledavidfurniture.ie. Castle David Furniture Sligo, where quality meets style. Redefine your home, redefine your life.
Jared Anthony has gone mad with 70% off all winter stock. You heard me, 70% off for the final winter stock clear out. Pop in today before the sale is over and get yourself looking smart, dressing smart and feeling smart with this fantastic quick 70% off for the final winter stock clear out at Gerard Anthony Menswear Superstore, Carrigan Shannon.
D. Keenan Welding and Repairs, the Northwest's leading metal fabrication company, specialising in bespoke gates and railings and all your metal repair needs. Call Diarmuid on 087 3315215 and open the gates to designing your specialised home or business gates and railings. That's D. Keenan Welding and Repairs. 087 3315215.
TB outbreaks hit 10-year high. For more in your Irish Farmers Journal, here's Paul Mooney.
We examine the latest department figures showing TB hotspots and reactor numbers. ICBF moves to address calf blue card delays. Find out how you can get up to €30,000 to renovate traditional farm buildings. What's driving some Western farmers away from sucklers? Top tips for maintaining your farm quad. Key farm payment schemes open for applications. Plus your TAMS questions answered.
All inside the Irish Farmers Journal. You cannot afford to miss it.
Breakfast is the most important meal of the day, so visit Dock 84 to get your day off to the perfect start. Now open from 8:30 a.m. each weekday morning, serving fresh barista coffee and delicious range of morning goods, from pastries to sausage rolls and breakfast baps to sit in or take away. Get your 9th coffee free when you join the loyalty program. Dock 84, the Mill Building, Finnisclin, Sligo.
Niall Delaney with good conversation and where your opinion matters. Call with your comments on 0818 365 500 or text 083 3500 530.
Right, okay, welcome back. Our panellists in this referendum debate are Claire Duffy, Maria Walsh, Sandra Adams and Rona Mullen. We've been talking about the family referendum. Let's move to the care referendum and the care amendment. And the proposal here in the amendment is that there be one vote for two proposed changes. The proposal involves deletion of Article 4121 and 4122 and replacing it with a new Article 42b, which states that the state recognises that the provision of care by members of a family to one another by reason of the bonds that exist among them gives to society a support without which the common good cannot be achieved and shall strive to support such provision. Well, Ronan, I'll put it to you first. We've been waiting a long time, have we not, for changes to what is patronising, sexist, outdated language.
Yeah, this is another example of something that could have been done, but has not been done. In fact, it's doing much more harm than good. And it's interesting that there's a lot of leadership.
Why is it doing more harm than good?
Because there's a lot of leadership being given by independents, funnily enough, in opposing these proposals, and none more eloquent than my colleague Senator Michael McDougall, as people know, former Taoiseach, Attorney General Minister for Justice, has pointed out the many legal flaws in these proposals, but also Senator Tom Clonan, himself an eloquent champion, disability campaigner, who is frankly insulted, I don't think I'm putting words in his mouth, by the wording on care, which is so weak as to give no benefits. On the other hand, then, in addition to giving a very weak and watery nod towards care, and even then only care within the home, the government is getting rid of the only reference to mother in the Constitution. It's interesting that the government falsely claimed on numerous occasions that the Constitution currently says that a woman's place is in the home. And of course, this has been given the lie to very effectively. And it was Judge Susan Denham who said that that in fact was a very...
But is the language as exists, do you not find it objectionable?
The
language of that article has been objected to by women for years.
You see, no, I think that's wrong. Some have opposed. It's interesting because if this was a wording that forced women to stay in the home, it should be out immediately. But this was a wording that actually offered to prevent women, where they mothers, from being forced out of the home by economic necessity. And there's tons of women and mothers on the economic treadmill at the moment who would love further legal support for their own decision to give care in the home. And in addition to that, they would love specific reference to the role of fathers as well. It was Miss Justice Denham, the former Chief Justice, who said that this clause does not assign women to a domestic role. It recognises the significant role played by wives and mothers, that it does not exclude women and mothers from other roles and activities. The work is recognised because it has immense benefit for society. That's a long way from the false claim from the National Women's Council and the Green Party that somehow says that women's place is in the home. The Constitution does not say that.
So Claire, the argument there is that there's no need for change. The women not need be put out or upset.
And what about the 39% of men that have consistently been enumerated in the census? They're not Claire Duffy figures, they're census figures. Or do we continue to ignore 39% of men who provide care?
No, we don't. We just add man and father to the article.
I am a mid-40s woman. I do not want to be defined in Article 41.2 in the way that I currently am, because I'm more than a mother. I'm proud to be a mother, but I'm more than a mother. And I just find it reductionist and hurtful that actually when Article, when the amendment or when the Constitution came out in 1937, women had a problem with it. They've had a problem with it for 87 years. It has never delivered anything tangible for women, including myself. And to think that we should wait another 87 years to see, can we squeeze something out of it?
That's quite true, actually. There are several cases where that clause has been cited in support, for example, of women's right to maintenance, very beneficially in the L versus L case. And it was also Chief Justice Murray in another case who actually said the Constitution actually implicitly recognises the value of a man's role in the home also as a parent. So there's a lot that's good there the government is in complete denial about. Okay. But why couldn't we have had a reference to mothers and fathers and the vital work that they do in the home? There's an allergy to recognising the difference between fathers and mothers.
That's
and it's particularly there in the Green Party and with Roderick and others. And there's an allergy to recognising mother and father-based parenting.
There's something very important to say, though, just about this article.
Sandra, and then I'll bring Maria in.
It's being, this article is being relied upon at the moment. There is a case before the Supreme Court. The mother of a profoundly disabled child is relying on this article to have her carer's allowance reinstated. €85 was taken from her because her partner, his income threshold went over the limit. Now, she is relying on this article that says she should not be forced by economic necessity to neglect her responsibility to her disabled child. This case was taken by the Supreme Court. It was going to be heard. The result will be out in April. The government knew this in December, and within a month this referendum was called. If she is successful in that claim, it will have profound implications for all carers, because they can rely on that article then to vindicate their rights.
Okay, but getting back to the overall issue in this particular referendum, do you think that the Constitution, in relation to this article in the Constitution as it stands, does it not make a statement about women over all these years that it was not acceptable and never has been for women? Would you accept that?
I don't think there's anything unacceptable about saying that some women are mothers and that there's a unique bond between mothers and children. This wording will take the word mother out and replace it with this amorphous word carer. I am not my child's carer.
Doesn't appear in 42B.
I am not a carer. I am my child's mother. And the carers in research by Carers Alliance last year stated that the relationship that they have to the people they care for is very important to them. They don't want to be described as carer. They want to be described as the mother of the person, the father of the person, or the son or daughter.
Okay,
so the words matter.
Okay.
Can I just...
Right, Maria.
Thank you very much, because we heard from Claire at the outset of this, and you shouldn't choose one over the other, but this is a very, very significant referendum question, very significant, and it is often it has created the most conversation, and in many ways, leaving outside the durable relationship piece, which we've discussed, but has also created most confusion. The current wording of Article 41.2 in the Constitution includes: the state recognises that by her life within the home, woman gives to the state a support without which the common good cannot be achieved. The proposal before us on March 8th is to delete Article 41.2 and insert new wording, and this is what Claire had alluded to at the opening, called Article 42B. And just to really stress, the state recognise that the provision of care by members of a family to one another by reason of the bonds that exist among them gives to society a support without which the common good cannot be achieved, and shall strive to support such provision. I call that out and I read it from a page because carer is not mentioned, care is mentioned. And it's incredibly important that, to Claire's points, and she works on this all day, every day, speaks with families, speaks with individuals who are trying to be protected under our constitution that is, in my eyes, outdated, and that we need to have the balance and remove the misogyny language and be more inclusive the setup of families right now.
We do have protection for the women in the Constitution in our current wording that has not been exerted, but protection is there. Would you accept that?
Well,
or not?
Women is listed twice because there's also a narrative. Women is still included. The term woman is still included in women. Excuse twice under the social policy article. If we're going to be really quite specific, the term men is listed more times than one can count, and is very highlighted in the introduction of the Constitution. So if we're going to get balance, I'd actually be pushing for balance throughout the constitutional text, but that's not what's before us. 2 referendums before us, one on family, one on care. And ultimately, from the referendum on care, it is to recognise both women and men. They have a role in offering care within families, and to give the constitutional recognition to care for the first time. You know, I really don't think anybody on the no side or yes side can argue the fact that we all deserve choice, and for many reasons, and for whatever reasons, in 1937, in reading of that Constitution of 41.2, women were given less choice than men, and now we are righting that wrong and modernising our Constitution to reflect care and the support of families that are needed within the family. And no better person to speak about this than Claire, who works on this in a day and day out.
Roni, you wanted to say something.
Why would the state want to open up the possibility that mothers could be forced by economic necessity out of the home? Why would they neglect the opportunity to put in a reference to mothers and fathers and the valuable work they do in the home? And why are they mixing in the two issues by offering a weak wording on care at the price of getting rid of the only reference to mother? You talk about the carers, Tom Clonan again, he says, this wording on care is such a lost opportunity and it adds insult to injury. It is a slap in the face for disabled citizens and the huge community and network of carers. I believe these proposed changes are going to fail, and what a waste of an opportunity, apart from the waste of
that's just one person's.
Can I just stress?
Defender of the rights of carers and the father of a disabled
Right, Maria, and then I come to
Sandra. To counter-argue that, the term strive is put in there for very specific reasons. From an Irish perspective, the dream. It's to upward momentum and push forward. And this is to put onus on the government and future governments to continue to improve care. That is a very, very specific word, care and strive, so that we are being inclusive to all and not some. And we're constantly moving towards
the state shall provide. If they were sincere about doing something from carers, you have 4 words: the state shall provide. It's there on free primary education. Why isn't it being offered?
Okay, Sandra, you wanted to comment on this.
Yeah, I just want to point out that this amendment locates the responsibility of care back within the family. The Citizens' Assembly advised or recommended that supports in the community would be referenced in this. Tom Clonan has stated that as well, and it didn't happen. The words must and will are not included. That would give some enforceability. And we know that organisations, the organisation Equality Not Care, the Irish Council for Civil Liberties and FLAC have all expressed concerns about this amendment. Dr. Margaret Kennedy on RTE on Wednesday said that it perpetuates the notion that disabled people are a burden and that it is ageist and ableist. It is not equality. It is making a bad situation worse.
Okay, Claire, I want to ask you a question as the representative of Family Carers Ireland. Does the wording strive to support, does that actually give carers anything at all?
Can I just take a little step back, and I will answer your question. Can I just say that in the Citizens' Assembly, 94% of the people there wanted Article 41.2 changed. 84% of them wanted it changed to recognise care, and this does exactly that. Strive. Look, Ronan, you made a comment earlier that the wording that we've got in 42B is not as strong as the wording that was presented by the Citizens' Assembly. The wording that was presented, and it wasn't wording, it was a recommendation for wording in the Citizens' Assembly, that 41.2 should be deleted and replaced with wording that is gender neutral. It does that it should recognise care in the home and the community. I acknowledge it's left out, as Sandra has said, the community piece, which is Tom Cloonan's point. And it goes on to say that the state shall be obliged, and I get obliged is a strong word, to take reasonable measures Where is the ambition in the word reasonable measures? I can pay someone a carer's allowance of €150 per week and say, I've taken a reasonable measure to support you. There's no ambition. The word strive, just wait, Ronan. The word strive implies continuing to work towards something, to continue to improve it. If we said we shall support, I could give you again €150 for carer's allowance. I have supported you. There you go. Strive is a continuous improvement. And I have used the analogy of, if we get 42B passed on the 8th of March, on the 9th of March, we don't get a switch that turns on a light that will lift every carer and give them rights on the 9th of March. That doesn't happen. It gives us a dimmer switch that we will turn up gradually over time to give them more and more rights over time. More rights over time.
It's dumber and dumber.
All right,
just it's the absolute truth.
Ronan, just respond to what Claire is saying. I'll bring
the free legal advice centres. Senator Tom Clonan, so many carers and people who have skin in the game are disgusted by this wording proposal because it's a nothing burger. It pretends to give something and it gives nothing. And it does even that then at the price of damaging the role of fathers and mothers and respect for what they do within the home.
It's given us nothing, and we've given it 87 years.
You deserve a lot. And this is why you... Can I ask you though? I don't know whether you get money from the state as an organisation or not. I know that you do.
It's irrelevant.
Yeah, I know that you do. I know that you do good work, but I also know that Roderick O'Gorman gave a veiled threat at the start of all this and said those NGOs who aren't on board.
You're not suggesting that the money for family carers will be removed if they don't come out publicly and support it. Yes.
NGOs feel really free to oppose the government
feel
on
really
this
offended by that comment.
No,
and actually look at any of the documentation.
As I said, I have visited your office. I know your work. All right. But is there a sense of pressure from the government here? If you felt that this wording was really problematic,
no pressure
would you
from
feel
government.
free to oppose
We
it?
have
the fact
never.
That you would say that as a senator is ludicrous.
That the
government.
All right. Okay. All right. I just.
We have published documentation. We look at our most recent publication, the Family Carers Scorecard. We scored government regressive on 4A. If we were worried about our funding being cut, would we be so outspoken about the areas that need...
Is it even funding? Is it about access? Because there is a real centralisation of power by this government. And when you had Roderick O'Gorman coming out and saying those NGOs who call themselves progressive, who don't support this proposal, had better come out and give a reason, that was felt by a lot of people to be some
Senator,
kind of... I absolutely am. And I think that was felt to be a veiled threat. Would you like to quote what he did say?
All right, I'll bring Sandra and then Maria on this issue. Sandra, you wanted to say something.
I just want to say that, when has this state ever willingly met its obligations to vulnerable people without being dragged by the ears to the steps of a court? And I don't think anything is going to change. There's a quote I like to use by Maya Angelou: when someone shows you who they really are, believe them the first time. Every day of the week, parents are taking judicial reviews to get school places for their children with additional needs. Now, why do we believe that this weak wording is going to force the government to do anything? It has shown us, it's not just this government, it's successive governments. When they are not forced to behave with decency, they will not behave with decency.
Okay, women did not ask for this change, Maria Walsh. Would you accept that or not? There's a lot of people who feel...
I wouldn't accept that.
That there was no pressing need to change it. Would you
well, there is a
it?
pressing need. If something is written, well, first to the point I made earlier, 32 changes have been made to our constitution to better and reflect the values in the current society we live in. And these two, referendum of family and referendum of care, have been long on the discussion table and unfortunately have not come before the people until March 8th. And these are progressive. Do they go far enough in carers? No. Or for care? No. But it is, to Claire's point, the step in the right direction after X amount of years that we need to better suit. I know from my generation, the fact that we've had...
because it's all we're going to give.
No, just let Maria finish and I'll come back.
Not, I mean, if March 9th we wake up and we have 2 yeses, which I hope we will, then it's not as if Claire and any organisation, myself included, as a policymaker at a European front, sits back and say, we've achieved. Now we then begin to work on review of the Disability Act to ensure entitlement to services. We begin to look at a European front in terms of the UN Convention on Rights of Persons with Disabilities and to deliver more there. Work to be of service to the community never ends. But these two changes are to reflect the society we're living in now and the values we have. That is why we're voting for.
Just on Claire itself, Claire, would you be disappointed that there are not more maybe robust guarantees to financially support carers going forward?
It's absolutely what we'll be working on. I mean, if we get a no vote on the 8th of March in relation to 42B, what does that say to this government about the value we place on care? We are on the back foot if we get a no vote for this. If we get a yes vote for this, which I hope we will, our work, as Maria has said, begins on the 9th of March to absolutely hold government to account and say to them, you said you would strive, here's what we need. And we've already started that work. We are looking for the full abolition of the means test for carers allowance. We're looking for participation income for carers allowance that recognises the immense contribution that they make, valued at €20 billion every year, the contribution that they make to the society. We are looking for that rights-based, Senator, that you referred to, a right to a break. I'm looking forward to being off tomorrow on Sunday. Carers don't have that right, so absolutely.
I was involved in caring for my late father for 10 years
Senator,
with Alzheimer's. I totally love and appreciate the work being done by carers, and I recognise the importance of what you do as an organisation. But I think that you have been captured on this one by the government with something very watery, and why they have to do that at the price of attacking the rights of mothers and fathers within the home.
All right. Can I put a point?
Sorry, if I can just finish the point, because Claire asked, what will it say if this is rejected? I'll tell you what it'll say. It'll say to the government, can do better, come back with proper recognition for carers, and don't be using carers as a wedge to attack the rights of fathers and mothers.
I would suggest that Sandra, I would suggest if it's rejected, a no vote will suggest that Irish people want to retain references to a woman's place being in the home. That's not something.
There is no reference to a woman's place being in the home. That has been clearly established. It does not say woman's place in the home.
Is it not an important vote that reflects who we are as a society?
Look, when you have something that nobody ever denied that this could be tweaked. The way to tweak this was to recognise the value of what both mothers and fathers do within the home, and to continue with the promise not to force mothers or fathers by economic necessity outside of the home, to get that proper work-life balance which most of the country craves. But
it recognises only women.
Not male. That is the change they could have made. But instead, because they don't like any reference to mother being in the Constitution, there is going to be no reference to mothers or fathers or what they do in the home, and all they've given to carers is an unenforceable promise of respect. That is not the way to change the Constitution.
Okay.
It doesn't use the word.
And anybody else want to come in?
Yeah, I'd just like to say,
Sandra.
there's the phrase a woman's place is wherever she wants it to be is being used extensively, but it seems to me that the only place she's not allowed to be is at home if she wishes, and that's really important to state. If a woman chooses to remain at home, she should be supported to do that. Just with regard to the care amendment, this government this month refused to ratify the optional protocols on the UN Convention on the Rights of People with Disabilities. Tom Clonan mentioned this in his speech. How can we trust a government that is speaking out of both sides of its mouth? It says on the one hand, we respect carers, we want to do better by people with disabilities, and in the same breath refuses to ratify a UN convention that would uphold those rights.
Okay, there's lots and lots of texts and comments coming in, and we haven't time to get around to probably most of them, but a general question I want to ask all of you, is this referendum needed at all in terms of how much it's going to cost and what it tries to do? Are there not more important things to discuss and change in our Constitution? Maria, do you think?
It's fundamentally important. Our Constitution is not reflective of the society or the values we have in this country right now as members of the European Union, and the fact that we have people not recognised within our current text. Therefore, these two questions on March 8th are fundamentally important not to put words in your mouth, Claire, but as stressed by her and by myself over the last 50 minutes. Work doesn't just stop on March 9th, whether this passes or does not pass. Fundamentally, we continue to serve and strive to deliver for care within the home for families, and we continue to build more equality within our country. So these two questions are fundamental, and they're the cornerstone of our democracy. Therefore, I cannot stress enough to get people out to vote and make sure on March 8th we are reflective of that community and the country we strive to.
All right, okay. Same question to you, Sandra. Is it a referendum that's needed, and considering all the money involved and so forth, is this something that should be held?
I think we can always do better we can always strive to do better for our citizens and to make our society better. 20 million euro would buy 1 million personal assistant hours at the rate of €20 an hour. That would be a meaningful contribution to the lives of disabled people to help them live independently. €20 million is currently being spent on building 2 domestic violence refuges for women. We could have had 4 with this money. So I don't think it's a valid or useful way to spend money or to declare your support for families or for people with disabilities.
If it is 20 million, Claire, it could do a lot for the people that you represent.
Yeah, but the examples that Sandra gave aren't for the people that I represent, which is family carers. Look, our entire health service, just by way of one example, is reorientating through Sláinte Care, and no one ever talks about the fact that it is entirely predicated, that new model of healthcare, on families being willing to provide care and pick up the bulk of that care. We absolutely must recognise care in the Constitution. We are 30 years kicking this around, and it's just time that it is there, and that the immense societal value of care is reflected.
Right, I don't suppose you would be in favour of holding a referendum at any stage, Sandra, and indeed you said the process leading up to it was disgraceful and showed disrespect to the Constitution and indeed to us.
Yes, if I hope there is a no vote, it would be quite possible to come back, for example, on the day of the local elections and with a wording that would give proper recognition to carers. I go back to what I said about there's an ideological coterie in this government that has gone about a secretive way of producing this wording at the last minute, and spending 20 million of taxpayers' money is a phenomenal waste on such controversial wording, when what they could have done was had a longer consultation and used the local and European elections to put a less controversial question to the people. I've no problem with tweaking it to include fathers as well as mothers, for example. I think that'd be a great idea. I would be delighted if there would be real enforceable rights for carers put into the Constitution. So they've done the wrong thing and at tremendous cost to the taxpayer, and without even giving the people of Ireland the dignity of a proper consultation on it before it's put to them.
This isn't just care by mothers and fathers, and that's really, really important.
It's
for me to be able to sit here today with the role that grandparents play in facilitating people like me to go to. It's carers within families, and Ronan, you mentioned that earlier, that this was care within the home. It's not care within the home, because care within families takes place across homes. If I didn't have my parents to help me with my childcare, to allow me, I couldn't function.
Would you accept that non-family-based carers are excluded?
No, I don't. The term informal carer,
the
term family carer is recognised in the National Carers Strategy as including people who are non-relatives. It's a replacement term. In Europe, they use the term informal care.
This is clearly a limited reference.
Okay. Carers allowance. You do not have to be a family member to get carer's allowance for the person you care for. It is accepted that the term family carer includes caring for a non-relative.
This is a wording that clearly refers to the bonds between people. There's no way you can say that it includes everybody in the care scenario. That's what has people like Tom Cronin himself, an experienced carer.
Can I just come in?
Very quickly, Mary, before we wrap it up, because time is up.
I have met many people who provide care within the home, informally, formally. I have met families who are impacted that they're not recognised by our Constitution. Anybody who's trying to make a decision about how they vote on March 8th, go speak to people that these 2 referendums are going to be impacted by, whether yes or no, and then make your best, because you can speak to policymakers like Senator and myself, but ultimately Claire and the families they support, the individuals they support, really need us to recognise themselves and
recognise the modernisation and the values of the state. So speak to the lived experience versus the penantics of this.
All right, okay. No, we got it. We
have been misadvised. They think it's giving them something that it's not giving them.
We got to leave it there. Time is up, unfortunately. I'd like to thank you all most sincerely for your presence here today. Lots and lots of interest in what all four of you had to say. Claire Duffy, Maria Walsh, Rona Mullen and Sandra Adams, thanking you again because you travelled such a long distance to be with us here today. And we do hope, and it is certainly looking like the case, that the debate this morning has made the issues involved a little clearer ahead of polling day 2 weeks from today, the 8th of March. And as we always say, no matter what way you vote, the most important thing to do is actually to exercise that right and to go out and vote. That's it for the show this week. We're back on Monday morning next at 9 o'clock. Enjoy your weekend. And Kevin Fury's up next here on Ocean FM.